Hello, I'm Oshika Boteju. I'm a regulated immigration consultant and also authorized to represent clients and at the Immigration and Refugee Board, which we all call IRB. This short presentation is about the Bill C-12, which is a hot topic these days. I get at least 3 calls every day asking about impact of the Bill C-12 from temporary workers, students, and refugee claimants, and like who wants to apply for a refugee claim in future. If passed, Bill C-12 could represent a significant shift in Canada's immigration framework, particularly in how temporary residents and refugee claimants are managed. While not necessarily a complete overhaul, it may make an important turning point in policy direction. Before we start, please note that this information is for general and education purpose only. If you need case-specific information, like what's happening with your case, like if you're a student or a worker, or if your claim is already at the refugee board, or like it is on the queue, you should contact regulated immigration consultant such as me or like immigration lawyer. So what is Bill C-12? It's a proposed federal law aimed at enhancing border security and updating immigration protocols. Firstly, it's important to note that Bill C-12 is not yet law. It is at the third hearing. It will soon become law with amendments or without the amendments that proposed. But it is proposed significant changes to the Immigration and Refugee Protection Act. The focus is on two main ineligibility rules it intends to introduce. One key change is that any inland refugee claim made more than a year after arriving to Canada post June 24, 2020 will be deemed ineligible. This restriction applies broadly, affecting everyone from international student workers, and basically all the temporary residents. Additionally, claims from individuals who crossed irregularly from US and waited over 14 days to file a claim will also face this ineligibility. This is not people who are coming from the airport. This is irregular boarders. The bill suggests these new rules will apply retro to claim filed after June 2025. What this means is this bill introduced in June 2025. So anybody who made the claim before, they will there's chances that this ineligibility rule does not apply to them. But anybody who did apply for refugees after June 2025, if this bill passed without the proposed amendments. So when dealing with the ineligible refugee claims under Bill C-12, individuals have the option to apply for pre-removal risk assessment, widely known as PRA. This process allows them to demonstrate that risk they may face if returned to their home country. However, it is important to note that ineligible claimants lose their right on Immigration and Refugee Board hearing, which is a significant change. The absolute rules introduced by Bill C-12 mean that any claim made beyond the specified time limits, that is that 1 year bar, will not refer to IRB. The only resource for these individuals is the PRA, which has much higher standard of proof, can be challenged to meet. Legal experts have raised concerns that these strict measures may deter legitimate refugees, such as those who have suffered abuse and delayed reporting from seeking asylum. These raise questions about the fairness and accessibility of this process. It's crucial to understand these implications and consider how they may impact those in vulnerable situations. So if someone you know, or like if you wanted to apply for refugee and if you are here like on a temporary resident visa, student or a temporary worker, and you are planning to apply for refugee with the previous or the current law says you are eligible to go to IRB for a hearing, a fairness hearing, but the PRA has a very high stand. PRA will decide by immigration officers or CBS, which I will discuss in my next slide. The pre-removal risk assessment, also called PRA, is a crucial process of individuals in Canada who are facing removal orders. The removal order, usually when you make a refugee claim, you get all the rest with all the like work permit, and then you get your interim health, but you'll be issued a removal order because if anything, like if your refugee claim is refused, the removal order will be active. So this includes those who refugee claims have been either finally rejected by the IRB or the deemed ineligible. When you receive a removal order, CBS officer will determine if you are eligible to apply for PRA. So PRA is not something that you go ahead and apply. You should be given the PRA. If deemed eligible, the officer will provide you an application kit to start the process. It is important to understand the PRA is not automatically granted. It's a separate assessment based on new or additional risks that you might face if you return to your home country. Decision on your PRA application will not be made by IRB. They are trained to understand the risk and the vulnerability, but it is the decision made on PRA applications are from IRCs and CBS offices. They are not actually trained to do that. That's the risk of this bill if approved, because ineligible applicants will go to PRA, and then PRA process is much on higher standard than IRB. So understanding PRA process can be daunting. It is an essential step for many seeking protection. So let's break it down what this process actually entails. As I mentioned earlier, like in practice, PRA is a lifeline for individuals who refugee claims have been refused or deemed ineligible. It allows them to request protection based on the potential risk that they might face if they were returned to their home country. And then the disadvantage of this PRA application, these decisions are made by immigration officers, CBS or IRCC, not the IRB. IRB officers, IRB members are trained for this sort of process. Also, PRA, let's say more than 80%, there won't be hearing at PRA. So then individual lose their lose the ability to present their case to IRB, such as IRB, like explain. When you explain your case, we call it like hearing. Then people will see your emotions, like they understand what you went through. So in PRA, like if there's no hearing, this will be a disadvantage for the claimant. So the PRA will consider three main aspects, like risk of persecution, danger of torture, risk to your life. Specifically, we'll delve into these three essential risks. The PRA process is designed to ensure that individuals who might face serious harm if returned to their home countries are protected. Firstly, the risk of persecution is a significant factor. This refers to threat of serious harm or discrimination based on aspects like race, religion, nationality, membership in a particular social group, or political opinion. Well, like we need to understand in the IRB process too, like these things will be considered mainly, like PRA won't dig through this process. Secondly, the risk of life is assessed. This encompasses situations where individual life could be an imminent danger due to conditions such as armed conflict or severe human rights violations in their home country. Lastly, the danger of torture. It's a paramount concern. PRA takes into account any credible evidence that an individual might subject to torture or inhuman treatment once returned to their home country. With this in mind, it's clear that PRA plays a vital role in safeguarding human rights. Next, we'll explore how these considerations impact temporary residence and the legal nuance involved in this compliance monitoring. So, what's the impact on Bill C-12 to temporary residents? When discussing the impact on temporary residents, it's crucial to highlight three main points. First, compliance monitoring become more stringent. This means that all temporary visa holders must be more vigilant about adhering to the conditions of their stay. The bill enhances compliance's expectation, though it's important to note IRCC reassures that these powers won't immediately strip someone of their status, because it says officers can take away your status if Bill C-12 pass. Like, that's not how it's gonna work. So you don't have to really worry about that. Secondly, the sharing of data by IRCC is set to increase. This means that how a temporary resident has complied in the past could affect future applications. It is essential to maintain a clean compliance record to ensure smooth processing of the future applications. Finally, the Canada Border Service Agency, or CBSA, now has expanded powers to document inspection at port of entry. This means that temporary residents should always be prepared for inspection by keeping their document up to date and easily accessible. These changes underscore the importance of maintaining compliance and being prepared for any inspections. So let's focus now on the implication of the bill for compliant temporary residents. First, while you may not see immediate changes, it's crucial to remain diligent. Ensure you obtain your permits lawfully, maintain your status, and adhere strictly to all conditions of your work permit or student permit or visitor record. The bill broad orders mean any fraud or violation could have serious consequences. Maintaining full compliance and accurate documentation is important than ever, especially with the possibility of sudden policy shifts like program suspensions. Additionally, for refugee claim decisions, the Refugee Appeal Division and Federal Court are still available. However, the timing of enforcement has changed significantly. Under C-12, removal orders become final much quicker, 15 days after notice, if the Refugee Appeal Division refuses an appeal or if none is filed, compared to the previous 30 days in many cases. So as we wrap up today's session, I want to extend a heartfelt thank you to each of every one of you listening to me. I hope the information shared has provided valuable insights and clarity on this topic discussed. Should you have any questions or wish to dig deeper into any aspects that we discuss, I encourage you to reach out. You can give me a call, send me a WhatsApp message. I'm here to support and guide you through any challenges or decisions you may face. Feel free to give a call or consult at your convenience. Also, there are a lot of immigration lawyers, immigration consultants out there, who are willing to provide more assistance on because of these bills changes in the Bill C-12. So just reach out to anyone. I look forward to the opportunity to assist you in further. Thank you. And guide, this ineligibility will apply to you.